I'm Teddy Downey, executive editor here at the Capital Forum, and we're joined by my all-time favorite patent expert, Tahir Amin, co-founder of I-MAK, for a conversation about how pharmaceutical companies use the patent system to delay generic competition and sustain high drug prices. We're going to be talking primarily about I-MAK's new report, Overpatented, Overpriced. They also have a new drug patent book database, which is incredible. And Tahir, thank you so much for doing this today.
No, I appreciate it, Teddy. It's always a pleasure to join you to talk about these things.
Let's just get into overpatented, overpriced. You look at some specific drugs. Maybe you can just give us the background of how you came up with that idea and sort of why now for these particular drugs. And then, I would love to go from there and get into the specific tools that the companies use to sort of protect themselves against competition.
Yeah, no, thanks for making that the opener, because it takes us back to 2018 when my organization, we basically wanted to sort of unpack what was the patenting situation around a lot of these top selling drugs in the United States. And so back in 2018, we looked at the top selling drugs I think it was 2017, 18 at that time. And what we found was the numerous patents, dozens, even hundreds of patents that were surrounding some of these top selling drugs. I mean, obviously some of the listeners, and I know you do, Humira was one of those drugs which became the poster child of where drug companies, in this case AbbVie, are able to amass hundreds of patents and then use them in litigation to beat over the competition, to make them surrender in court and delay entry. In that case, it was a biologic drug, so biosimilars. And that really then put us on this trajectory of like, how do we help sort of tell the story of what is going on in the patent system? And it was out of that basically we ended up with this latest version of the report. We did one in 2022, and that's when we first released the database that you mentioned in the opening. And we've just updated that now with 10 more drugs, many of which I think all of them are actually were in the last round of negotiations for the Inflation Reduction Act. And then we've also included the drugs Ozempic, Wegovy, and Rybelsus, which were part of the current negotiation round for the Inflation Reduction Act. So this database now holds 20 pharmaceutical products, which are some of the best-selling ones in the United States. And we have identified all the patents that we can identify that relate to these drugs. And that's not to say that it's an exhaustive list, or because anybody who's worked in the patent profession or is familiar with it, sometimes it's very hard to find what patents relate to which drugs, because the way they're written. As a lawyer who's worked in the intellectual property space, lawyers deliberately obfuscate terms so that examiners can't find them, so that anybody searching can't find them. And then when you get into the biologic sector, which many of the top selling drugs are today, then the technicalities get even more difficult, and sort of very close wording nuances make a difference whether a patent covers a drug or doesn't cover a drug. And so some of it becomes very subjective, and that's why we end up in court. So that's how really this whole project came about. And then what we did with this latest report, which came out a couple of months ago, was to just pick two of the drugs that were part of the negotiation rounds last year, and that's Eliquis and the drugs that are going to go into the next round of negotiation, Ozempic, Rybelsus, and Wegovy. And it was really just tell a story of like how the patent system is skewing both how we get generics into the market, but also how it's skewing the negotiations that are taking place in the Inflation Reduction Act. Because essentially, many of the drug Eliquis, for example, has been generic in Europe since 2022. Yet here we are negotiating a drug to lower the price on that's still under patent in the US. And we can get into perhaps the reasons why it's still under patent. Perhaps that's your next question. But that was the whole purpose, is to really show like, yeah, we've got this, we made some moves, we made some progress with the Inflation Reduction Act. For the first time, the United States is now negotiating drug prices like the rest of the industrialized world in the global north. But is it enough? And is the patent system still making us pay more even through those negotiations?
And yeah, I'd love to get into, some of the specifics of the strategies for these drugs that you looked at, Eliquis, Ozempic, Rybelsus, and Wegovy, you know, you list, let's just go down the list, or whatever's easier for you, by drug or by list. But you mentioned patent term extensions. You know, I'm familiar with follow-on patenting and patent thickets. You know, you've written about that before. Maybe you can walk us through patent term extensions and how that specifically is, you know, coming up in these with these drugs.
Yeah, I think patent term extensions is this thing that I mean, for anybody who's not familiar with the space, will probably has no idea what we're talking about. People get confused between, oh, you know, when we hear this, companies are extending patents. Well, how do they extend patents? You've mentioned the follow-on patents. So these are patents which are filed after the main patent. So just to bring it to basics, when a company is doing its research and development, it will file the initial patent that may then go on to become the underlying patent for a product. So let's, for argument's sake, say it's the compound, the main compound, and that is filed, and you get 20 years of patent term typically. So what happened in the the 70s and 80s? Companies were saying, well, by the time we go through research and development, we only have X number of years left of that main patent. So for example, let's say it takes me as a company 8 to 10 years to develop my drug through the process, get it approved by the regulatory authorities. Then I only have 10 years of market exclusivity where I sell the product. And so there was this bargain that was struck, and it was actually as the system of allowing generics into the market in the United States in the 80s. There was a massive bill which kind of changed the patent landscape dramatically. It's called the Hatch-Waxman Act, which some of your listeners may be familiar with. It was 1984. And there was this bargain that was struck. There was a trade-off. Generics could come into the market without having to do the full clinical trials, which was how it used to work previously. They could just do the sort of phase 3 bioequivalence, if that, show that their product is equivalent with the first branded product. And they could also challenge some of the patents in order to get into the market if they felt they were the patents were weak. And in return, the branded company said, well, we want to lengthen, at least have a more guaranteed longer exclusivity period. So there was this trade-off where patent term extension would give up to 5 years of an extended period of the main patent of the underlying active ingredient. And at least they would get 14 years. The guarantee was you'd get up to 14 years of patented exclusivity. But in addition to that, companies were also given, the branded companies, when they do their first drug filing, a new drug filing application, they get 5 years in the small molecule space. They get 5 years of market exclusivity. Not many people often talk about that. We always get so focused on the patents. But this 5 years guarantees the drug company a pure monopoly. Nobody can contest it, and it's a pure monopoly. And then running alongside that 5 years is the patent, the main patent still. So usually there's still some life left on the main patent by the time the market exclusivity ends, depending on how long approval took. And then in addition, for every new indication, for every new dosing, you get 3 years of clinical investigation exclusivity. So these were all incentives that were built in the 80s to help drug companies kind of do all these kind of tweaks and modifications and all this follow-on patenting that you see today. But they get market exclusivity, but yet they were still doing all the follow-on patenting. So what you have then is you have these overlapping extension systems. There's many different ways that companies can extend their patent. So let's talk about Eliquis, for example, one of the drugs we look at. The main patent on Eliquis was filed around 2002. So by traditional sort of patenting terms, you get 20 years from 2002. That patent should come off in 2022. But because of some regulatory delays and this agreement, this trade-off that was made in the 80s, BMS were given an extra 4 years. So now the patent expires in 2026. So we can't get generics in. In addition, BMS filed some of the follow-on patents, and they've utilized one of those follow-on patents in courts to prevent generics coming in until at least 2028. Now, we haven't seen the settlement. We don't know if there's a settlement yet. And it might be that some generics might not be able to come in on 28 either. We might only get one entrant. And that usually means the prices are not going to come tumbling down. FDA studies have shown if you get more than 6 entrants in, prices can come down up to 95%. So competition is an interesting term. People like to say, and I think there's a misleading way of describing competition when branded companies say, oh well, one generic has come in. That's not going to bring the price down. Competition is when you've got 3 or 4. They usually say rule of thumb 5. And then with settlement agreements, what kind of settlement agreement is it? Because if it's like limited volume that you can generic can supply over the first 6-7 years, which is what companies are doing now, that's not competition. But yet we're often sort of kidded into thinking that that's competition. Not to digress, in Eliquis's case, in that extra 4 years of patent term extension, so I'm not talking about the follow-on patents, just the patent term extension, which is a statutory patent term extension, we estimate BMS will make $39 billion. So we'll be paying, BMS for that branded $39 billion. And then if you add on the follow-on patent that they're using in court, which it gives them another 1.5 years or something, that's another $11 billion. So overall, BMS is eking out an extra $50 billion in revenue because of that because of the extension and the follow-on patent.
And ostensibly, this patent term extension in the Hatch-Waxman law was a sort of a fig leaf to the industry. Hey, look, we want to make sure that your amount that you get is sufficient to attract investment. But what you're saying is not only was that 39 billion not enough, they're doing more conduct afterwards to also, keep competition out. They're not saying, oh, you know what, that 39 billion, that's enough. That's part of this statutory deal that we had. They want more. Is that the right way to think about that?
It is, and I'm probably making a bad sort of reference here. It reminds me of the sort of I think the Rolling Stones can't get no satisfaction. That's what these guys are. They just can't get no satisfaction. If you look at it historically over the years, they pushed and pushed and pushed for more and more and more and more, and that's what's happening right now. And they will continue doing that because they'll keep using the quote unquote innovation argument that we need more incentives to kind of be incentivized to do the actual. And they're not even, as we've shown in another report we've done, and we'll get into Ozempic, Wegovy, and Rybelsus, the Novo Nordisk drug. They're not even spending all their money on R&D as they claim. They're doing share buybacks. They're doing, in Novo Nordisk's case, they spend more on share buybacks than they do on R&D, according to our understanding. And that's been a common business practice now since the 80s, when all this really kind of kicked off. So this bargain that was struck in the 80s was to kind of drive more investment, as you said. That's how the whole economy around intellectual property was kind of, that was the agreement. But now, with the sheer financialization, which is where basically it's all about shareholder value, that has become the dominant factor, and it's not R&D, which was what this whole agreement was supposed to be about.
And I want to, maybe the best way to do this is just focus on Eliquis and just go through everything there. Were there any other jarring follow-on patents, patent thicket, or other conduct that's sort of like legal shenanigans or legal strategies to fend off competition that stick out to you that that we can talk about, and then once we've talked about that, we can move on to the Novo Nordisk stuff.
No, I think at the moment, as we see it, it's the patent term extension, which takes them to 26, and then they're utilizing one patent. But we found they've They have up to 40 patents on the drug, even though only 3 are listed on the Orange Book. A lot of people like to point out, as our critics say, well, there's only 3 on the Orange Book, but they have a whole arsenal that, sometimes patents that are not on the Orange Book can still be asserted in litigation. People often forget about that, even though the Orange Book patents are usually the ones that are seen to be of more value. There are a number of cases out there where companies will assert a patent that's not on the Orange Book. And people need to remember, not every patent has to be listed on the Orange Book. The FDA itself says that you should actually check through the full rigorous due diligence to see all the patents, because the Orange Book only lists limited number of patents that are required under statute.
Why and how did they have standing in court to fend off competition when the patent is not listed in the Orange Book? I thought that was the whole point of the Orange Book, is to make it so that if you want to enter, that you could just look at that and say, hey, here are my, here's what I need to focus on. I mean, I should talk to, David, my colleague here, obviously. I wish he was on this call with us. He knows the answer to that, but even though I've read a lot about the Orange Book the past few years, I still am a little bit confused as to how you could use that in litigation. So I'm interested to hear, all right, they have 43 in the Orange Book. What are the other 37 doing? And like, how does that present a risk to a generic wanting to enter?
Yeah, so there are 3 listed on the Orange Book, and then we've counted, several others. They haven't used them as yet, as we've seen, as far as we know, in the courts. But we know from other drugs, other cases where companies have used non-listed patents on the Orange Book. For example, Celgene, in relation to the drug Revlimid, the cancer drug, they asserted a different crystalline patent which wasn't on the Orange Book against one of the potential competitors. And they're able to do that. It just goes outside of the Hatch-Waxman system. And as long as they can claim there's infringement of a patent, it doesn't always have to happen within the rubric of the Orange Book, at least as far as I'm aware. But of course, paragraph 4 litigation is usually where a lot of the game is played. But if a company feels that there's another patent that they have in their arsenal that they can use to delay a competitor, they're going to use it.
I mean, and let's go on to Novo Nordisk in a second, but this just seems like beyond a broken system. If you can just come up, with all sorts of ways to prevent competition, even go outside of the framework that Congress set up to facilitate generic entry, are we just at the point where this system is like just so broken it needs reform, or or are there things that, obviously this negotiation has been allowed for drugs. You can have the government negotiate on prices now for limited number of drugs, but what can happen that sort of either to narrow the problem, to address some of these specific problems that you're seeing, or do we need comprehensive legislative reform because Hatch-Waxman is just not a reasonable way to, facilitate entry?
I think your latter point. I think Hatch-Waxman needs to be essentially we need to start again with the bargain that was struck. I think it's out of date. I think the way the pharmaceutical companies have gamed it through various strategies, whether it be the follow-on patenting, in addition to the patent term extension, which was supposed to appease them, the settlements that they have, that strategy, maybe filing patents or using patents in litigation which are not even listed on the Orange Book. The list goes on. And I think we have to look at what are the consequences of the system as it is today. Blockbuster drugs today compared to what they were back in the 80s. I mean, let's talk about Wegovy, Rybelsus, and Ozempic. in our finding, the main patent, so a similar story to Eliquis, the underlying patent, the main patent, which was filed in 2006, should technically come off in 2026, according to that 20-year period. But because of the patent term extension, this bargain under Hatch-Waxman, they got granted another 5 years because of the regulatory delay and what have you. They filed a whole bunch of other patents. By our count, we've identified 320 patent applications, of which 154 have been granted. 49 of those are on follow-on, so new indications, formulations, because the drug, the underlying active ingredient, semaglutide, is a bit of a Swiss Army knife because it's got so many potential uses. It's still the same active ingredient, and many of these uses are being identified just by serendipity because of the, it was originally for diabetes. They recognized that people were losing weight, so hey, let's just file for another patent. So a lot of it's not real R&D. Sometimes people use these things off-label. Physicians try them out, and then the drug companies get wind of it and say, okay, that might be a good idea for a patent. And so, that all gets bucketed into R&D. Of course, somebody has to develop the drug through trials and stuff, but, what is a patent for? It's supposed to be novel and non-obvious, not because, you found out that you already know the mechanism of action. But anyway, in that extra 5 years that Novo Nordisk got through the patent term extension, we projected, based on earnings and forecasted revenues, they're going to make 166 billion in revenue. Now, when I look at that figure and I look back at what people thought in the 80s, I wonder if they actually thought that was the kind of numbers we'd be looking at in terms of today's market. And that to me tells me why we need to go back to the point we were discussing, why we need to look at Hatch-Waxman. I think the
166 billion just from the patent extension, not from all those other.
Not from all the other patents. No, not for the fact that they've spun out a different branded version for obesity, Wegovy, which is the same underlying active ingredient. They filed the whole, they changed the dose. They've got patents running until 2030 odd, 39 or something. I mean, some of the patents run until 2042. Whether they'll realize that full extent, probably not, but they'll use it in litigation to get as much as that time in their favor, which is what happens. And so, yeah, $166 billion that we're going to be paying on this branded version before competition can enter. That to me strikes me as like, did our legislators at the time even have, they probably didn't have they couldn't see the future. So what is it that we can't address that now?
One of the things that is, with these semaglutides is sort of a cheat code or what that we've seen is, these compound pharmacies sort of saying, well, there's a shortage, and kind of taking some shortcuts to provide, people with a lower cost option. Obviously, that's like arguably A, against the law, and B, not really a solution. But are you seeing that? Because this $166 billion number is just so huge, and because these costs are so, sort of astronomical, have you seen more? That's obviously one shortcut. Are you seeing more of that? And how is that coming into the patent discussion? Are you expecting just a wave of patent litigation, or as a person watching this, that's obviously not really a solution, but it's something that's come up, and I'm curious to get your thoughts on how that factors in here.
Yeah, it's been interesting watching this compounding phenomena, if you might say, around these drugs, because these drugs are being so many people have been desiring them, to use them for different purposes. And the compounding stuff, as far as I'm aware now, is the FDA had said, because there was a shortage, because companies like Novo Nordisk and Eli Lilly, these are GLP-1 drugs, in case anybody's not familiar with them. There's Eli Lilly's is tirzepatide, which is Mounjaro and Zepbound, and Novo Nordisk to the three drugs, Ozempic, Wegovy, and Rybelsus, originally used for diabetes. And the compounding was allowed because there was a shortage, particularly for the weight loss use. But the FDA shut that down now. So now we're seeing litigation happening where the Novos and the Eli Lillys are suing some of these compounders. And so the availability now has shrunk again. And I've spoken to various people. I did a podcast a couple of weeks ago or a month ago with some ladies who are taking the GLPs, and then all of a sudden the compounding with versions have gone, and they're struggling now to get these drugs. And so it's a real problem. And so now we're all at the mercy of Novo Nordisk again and Eli Lilly, because of the FDA has removed this what was a kind of ability for compounders to come into the market to meet the need. Now that's being stopped, saying because Novo Nordisk and Eli Lilly have ramped up production allegedly.
And it's interesting that could be a tool for when if the companies ever sort of artificially limit the supply, potentially, but obviously again not a real solution. And we have, it's interesting that we haven't even talked about bundling and tying and the PBMs. We're just talking about the patents, but if you are able to get through that patent thicket after the patent term extension, which, as you point out, can now be worth over, $166 billion. That's just such an eye-popping number. It does seem a little extreme, but let's say you do get through all of that, and then you have to deal with the PBMs and any kind of exclusive contracts or exclusive dealing to prevent you from getting on the formulary. So if you're a generic company, this seems like a real feat, a real you got to be a real gymnast to jump through all these hoops here. And one of the I'm curious, one of the things we look at, and I see in the press a lot, well, there's a patent cliff coming, there's a patent cliff coming. To your point, that's really the start of this process, right? When you get to court and then you have to deal with the PBMs, and you need 5 competitors, not one. I'd love to get your thoughts on, what we see when there's a patent cliff, and then also, also some of the stories about, you mentioned something I'm not quite familiar with these the settlements that, the novel ways that they're coming up with settlements with generic companies that prolong you got volume limits. I'm not familiar with all the sort of innovative legal strategies that are being used here in these settlements, but if you can talk about those a little bit, and then just the difficulty of getting a real patent cliff the way that Hatch-Waxman was envisioned, that would be interesting to chat about.
Yeah, can I just sort of start with the term patent cliff? That's a pretty recent kind of term that's came about in the sort of early 2000s. I don't know if any of you use I think it's called the Google thing, which tracks word usage over time. I don't know what it's called, Ngram or something. And if you type in the word patent cliff, you'll see that there's a flat line until about 2000, and then all of a sudden it just spikes. And I'm fascinated by language, because language is what shapes culture. And we have been shaped by this language of patent cliff, which is supposed to be a signal, this doomsday, that we're all supposed to feel bad for companies. All of a sudden, they're going to lose billions of dollars that they've been making through exclusivity, through monopoly. And now it's all over. And we're supposed.
It's funny you say it as bad, because I just think about it as the price going down, right? Like I just see it,
right.
It's like, well, the price is going to become affordable. So a patent cliff I've always associated intellectually as a good thing, but you're saying no, that's like a Wall Street term of like the doomsday.
It is.
How
It's
do
a
you
term.
fight off doomsday?
Yeah, it's a term that has entered our sort of lexicon and has shaped how we feel about these things. We go, oh, that's not good, and then oh, that makes us feel some kind of sensibility to, oh well, these companies have to do something about that, and and here we go, and then they do all these shenanigans, whether it be patent, follow-on patents, and all this is mapped out to your question of they're already looking 10 years ahead of what's coming down the line. I mean, it's like look at, for example, the drug Keytruda, which is the best-selling drug at the moment. I think the GLP ones, these weight loss drugs, are going to surpass it by given the estimates. But at the moment, Keytruda is like the best-selling cancer drug. It's got so many more indications than 10 drugs put together. It's the CEO, Rob Davis, who I happen to have the fortune of testifying last year in the Help Committee. He was asked by Senator Ray Lohan, saying basically when their main underlying patent on the main molecule is supposed to expire in 28, will you allow biosimilars on the market? And he gave a very sort of nuanced answer, which not many people picked up at the time. He said, yes, we will. But he didn't mention the fact that they've already planned to switch to a subcutaneous form, which is an injection, as opposed to the IV version that's currently on the market. And they already have patents lined up for that, which will extend it out to 2039. So these plans are made out. They're already looking, and it's called life cycle management, which I'm sure some of your listeners are familiar with. It's again another term that's entered our culture and business culture of basically keeping a popular product, its franchise, going for as long as possible. And you do these tweaks, and you use every loophole. And this is written in books by life cycle management strategists. They say this out very openly. Companies say openly, and in the case of Merck and Keytruda, Rob Davis, the CEO, on an earnings call said, we're going to switch 35 to 40% of the patients over to the subcutaneous form. And that means then the clock starts again under the patent of that. And this is the avoidance of the patent cliff that we're talking about. And he called it, well, it's not going to be a patent cliff, it's going to be patent hills. And Merck has filed, at least by our count, up to 300 patent applications on Keytruda, of which over 100 have been granted. And I think it's probably more than that, because trying to figure out which is what is a really tall order. So this is the patent cliff model now. And this is what we have to deal with. And this is why we have to start addressing these tactics, what you said in relation to, in Hatch-Waxman, but also in the biologic sector, which is where it's even more rampant and much more severe.
And let's talk about solutions. Obviously there are some potential solutions. You look a lot at Medicare data. There are some of these tactics are being addressed little by little. Obviously the FTC went after all the Orange Book, improper Orange Book listings. That's one small piece. Or big piece, depending on the drug. There's PBM reform that have moved through Congress and are constantly being threatened about in Congress, and there's FTC litigation on PBMs. But when it comes to patents, where is the patent office? What has come out of the patent office? I know you've done some work on a paper that came out of the patent office last year, related to some of the data that you'd put out. What's going on now? Where should we be looking as, sort of interested stakeholders, and how will there be improvements and, fights related to this sort of broken patent process, broken Hatch-Waxman process?
Yeah, I mean, there's a lot to unpack there. You've got so many different pieces. We've talked a little bit about Hatch-Waxman, so I'm going to just park that one to that side. And your point about the patent office is important, because ultimately this is where it all starts. the Patent Office is supposed to be operating as a public agency in the interest of the public. But anybody who has studied the economics of the Patent Office will realize that and it's a term that's used, they are suffering from regulatory capture, as in basically their clients is their focus is really on the commercial clients that pay the fees for their patents, and they're not really thinking in terms of the public interest, even though they may claim they are, because they're driving quote unquote innovation, which many of these patents are pretty poor in quality. And so this report that you were mentioning that the Patent Office put out was trying to sort of counter some of the findings that we had found in our report since 2018 and even more recently. And what it does, first of all, it doesn't address, and it says so even in a footnote in the report for anybody who wants to read it. It says it doesn't directly address all the data that we found. And all
what is the name of the report, just quickly, so people can look it
up? Drug exclusivity, and you know, and the report only focuses on Orange Book patents. It doesn't even look at the biologic sector. It only focuses on Orange Book patents. And as we've already discussed, the FDA itself says not all patents are listed on the Orange Book. And I think listeners and people who may listen to this afterwards, or people who are in this debate, only think that it's only the patents that end up in litigation that matter. That is a misnomer. As somebody who's worked in the IP field, and anybody, and having spoken to endless scientists, the problem starts as a generic or a biosimilar competitor. You're having to navigate these patents as they're being filed because you're doing your R&D to come up with your version. So what you're doing is, these are all landmines. This is even before you get to litigation. So even though a company may only use 10 or 12 patents in litigation in the end, that's not the number that matters. What matters is the hundreds or the dozens that they've already amassed, because you're having to work your way through them. And they become either a deterrent to a competitor to say, actually, I can't do this because it's going to cost me God knows how much to get through this, or it costs millions to get through it. And what you do then is you end up with a settlement. Now, I know I skipped the question what you said about these new types of settlements, and I'm kind of veering off a little bit, but I want to answer that question. And I think the FTC came out with a report early this year showing the new ways that in the pharmaceutical space that settlements are occurring. And the one example I want to give, which was actually in the Patent Office report, because they were trying to say, because we had said Revlimid had up to 40 years of patent protection, of which, you know, we won't see competition until 2026. And I think it's important to distinguish between patent protection and market exclusivity or market monopoly. They're two different things, and we try to distinguish that. In fact, in all our writings now, we say a company has amassed 40 years of patent protection, i.e. they have patents that run on a particular drug in whatever form for 40 years, and that's true. They have patents that do that. How much of that market exclusivity they will get depends on what happens in court. So to give you the Humira example, even though they had patents running till 234, they struck a bargain to let competitors in 223, but they got 7 extra years from, you know, their underlying patent was supposed to end in 2016. Those 7 extra years were worth 114 billion by some accounts in revenue. That's a good day's work for them. All those patents that they filed, the lawyers and what have you. That's what this game is. So what the Patent Office is trying to do to undermine this conversation around, oh, companies are amassing lots of patents. They're saying, well, that they don't get exclusivity for that full period. Yeah, we know that. But it's a game that has been playing to extract as much as possible beyond the main patent.
And just so I understand, the Patent Office is basically doing a report that essentially regurgitates industry talking points. Is that
100%.
Is that a fair way?
That is a fair way to do it.
Is that a rigorous? Is that the type of rigor that you've come to expect? The lack of rigor out of the Patent Office, that they can just call up an industry trade association, call up pharma, and say, hey, you know, we're interested in some of your talking points, and then launder that into a report? It seems very I mean, from my perspective, it seems just outright scandalous that would be some kind of conclusion of of the patent office to end up there.
I mean, I'm not saying they did that, but what it sounds like, it does sound like it. Now, one of the examples they give is Revlimid, and they say, oh, well, actually, I-MAK's wrong because they said there would be, 30 years without of monopoly. We never said that. We said potentially. Depends on the court case. But they don't look at the nuance. They like to paint it in a particular way. And then they use that Revlimid, Celgene's Revlimid, as a cancer drug, to say that, oh, well, competition entered in 2022. But what they didn't look at is they didn't look at what the settlement was. And the settlement says, and it's on Celgene's site, BMS's site, that there was basically a staggered volume restriction for the one company that entered. So basically that meant that the generic that got the settlement could only make 7% of the annual volume that Celgene made. And then it increased to 12%, then it increased to 15%, then it goes up to, and then only full generic entry can enter in 26. That is what the Patent Office is portraying as competition. And if that is a definition of competition, then, I've got a bridge to sell you.
How much, I mean, I just want to stay on this for a second. It just strikes me that it wouldn't take very long to actually dig into the details. I mean, you call it nuance, but like, my experience with this is you just do more research to learn what's actually going on. It's actually kind of hard to do a cursory level. It's hard to end at such a, superficial level and be like, this is our conclusion.
Yeah.
Especially if the whole point is to do a study. I mean, how many years did they spend doing this study to end up not knowing anything about this market, right? Or coming up with conclusions that not useful to any reasonable person who wants to make a decision. Strikes me as very troubling that superficial level of research is being done at the patent office. But we've been on this call, we've done this call, a version of this call for a while now. I mean, it's been a while since our last one, but the last time we spoke, there was a problem at the patent office for just allowing way too many patents through that are not actually real inventions, that are just sort of based on utility or some lower threshold. Is that, are you seeing that just more of a pervasive problem at the patent office, that not only have they lowered that standard, but that they're just so, sort of catering to, sort of the branded drug companies, that there's just no useful research coming out of there? Or is it beyond? I guess the point is has it gotten even worse than lowering the standard at the patent office?
I think the demise, if you want to call it that, some people may disagree with that word, but the demise has been set in, the rot has set in a long time ago, and as whether it's got worse or not is, I think, and these are policy choices. I think these are actual policy choices. One of the problems with the patent office is, I think this report reflects it, it doesn't take any responsibility itself for granting these patents. It just says, oh, we're just going to look at what the eventual market exclusivity was of a drug, and it's not as long as what people claim it is, and that's it. We're not even going to talk about all the patents that we grant, because that's all we do is we just grant them, and then the market, the courts, the litigation system sorts it out. That's the system we have, and the patent office is happy with that. Frankly, I think that's diabolical, because you're supposed to be the vanguard of a public interest, and that contract is not there anymore. And the social contract of a government right, which is what a patent is essentially turned into a private right, almost like there is no public say in it. And so when you go back to this idea of, well, what patents should we be granting, and the bar, and the whole thing is as I like to say, and people may challenge this, and I'm happy to have this discussion, the patent system today is not about invention. It is about, it's an investment for exclusivity system. If I can say, all I have to say is that I'm invested, I've come up with some utility, and I get a patent. The novelty factor, the non-obviousness factor has pretty much kind of just become diluted and is kind of almost secondary, because we want to drive and grow the economy through quote unquote innovation. And innovation is a much lower standard than invention. And this all happened in the 60s, 70s, and 80s, and the economy turned this way, probably because of technology, the way it was evolving, but largely because to drive investment. And so this is why we have so many more patents today. And that is a fundamental problem. It's a economic policy problem, which is hurting millions, not only in the US, but around the world.
And I want to say on this for a second, because you mentioned policy choices, but there are also personnel choices. And the Biden administration had a really comprehensive anti-monopoly regime in place, but it was fairly focused at the FTC, the DOJ, maybe a few other areas. You could see it popping up, notably at the Department of Transportation late during Pete Buttigieg's tenure, but really kind of scattered, not totally comprehensive across the whole government. It seems like what you're saying is that the patent office was effectively left, it did not, and who are the types of people that go in, have been at the patent office? Are we seeing a shift with the Trump administration? Is it business as usual? And then there's sort of the high level appointee, and then there's sort of the, obviously Republicans and MAGA, they'll call it the deep state, but sort of the bureaucracy. Are both, you said the rot has set in. Do we have that from the top down? Is it all the way through? Where do you see, and has it changed at all?
Yeah, I think this is not a Republican or a Democrat sort of difference. I think both parties have created the rot. In fact, in many ways, it started from Carter in the late 70s, and it's happened all the way through. In many ways, I think it's the impact of neoliberalism, if to use that term, which is always a loaded term for some people, but it's effectively what has created this way of reducing any kind of government sort of overview of systems and leaving it to in the interests of the market. And I think we're going to get potentially what we're seeing at the patent office now under the current administration. We're seeing a lot of the things that maybe were slightly moving in a different direction under the Biden administration, under Kathy Vidal, who was the director. There was a little bit of space there where there were some things that she's proposed that eventually have now been removed, and now we're back to a worse version. So we're often oscillating between this, we're kind of slightly trying to fix a few things, but not really, to getting worse, and it never gets better. And you're right, the patent system is almost off limits for any kind of critique for any of the administrations.
What's interesting about this is, the Republican Party obviously is, there is bipartisan interest in Congress to address the PBM issue, which is fundamentally a drug price issue at some level. You have even Trump going out of his way to talk about trade, tariffs on pharma, most favored nation clauses in pharma. And yet, so there's clearly a political will around drug prices. How do you explain the disconnect between the high level rhetoric, the policy initiatives related to drug prices outside of the patent office, but then the patent office seemingly just not only going about its way, but getting even worse, even as that rhetoric ratchets up elsewhere?
Yeah, it's amazing that we'll do everything but go to the source of the root of the problem, right? And I think the reason for that is because patents are seen as this engine of the economy and the investment flow, and if we mess with that, the sky's going to fall in. And I think that's what prevents people even tackling. I mean, there are bills out there. There are bipartisan bills. I mean, there was one called the Ethics Act, which just got passed got put through Senate by Josh Hawley, Senator Welsh, and it goes, it tries to tackle some of the problem, but we never get so far upstream where we say, actually, why are we granting these patents in the first place? And until we address that fundamental issue, we are going to be stuck in this place for a long time. And I think it serves a lot of interested parties to keep it that way, whether it because people think it serves the US economy, which I don't think it does. In fact, I think it's actually denigrating the R&D capabilities that the US has, because what we're doing is we're focused on these little increments as opposed to actually really bringing new value, new knowledge into the marketplace. And people can have all sorts of debates about that. And that's why I think the innovation, the language of innovation, has handicapped us to do less as opposed to do more.
Yeah, I mean, the incentive is to get more lawyers, not more scientists.
More scientists, and put those billions of revenue into real lab work and your employers. Instead, I'd rather pay off my shareholders and investors.
And I want to talk about litigation. Is there any litigation that you'd point to that actually is promising that some court fights are pushing in the right direction, that you've got some court decisions that are encouraging, or is it bleak? And if not that, state investigation, anything where we can sort of say, hey, these people get the problem and are digging into it, and anything worth following other than, even at the legislative level, but courts, states, something where there's movement.
I think from a congressional level, there have been 6 bills sort of around patents. I call them sort of patent adjacent, as in they don't tackle the granting of patents, as in raising the bar for what deserves to get a patent. But what it does, it tries to minimize the number of patents you can use in litigation. So it's trying to address some of the patent thicket problem, where companies amass lots of patents and use them in litigation, or at least threaten to use them. That's as good as we've got in Congress. And I think, we have to applaud at least that. And it's bipartisan, and it's, we say, okay, you've got, at least you see some of the problems. And I think we didn't have that 6-7 years ago. So I see that as progress, even though it doesn't bring really tangible, sort of meaningful change to people's lives at this point. I think in terms of cases, actually, I'm not aware of anything that really strikes me as tackling that fundamental upstream problem. And I think we're a long way away from that. I think there are some cases, some antitrust cases, which are brewing through the court. I think there's one where, and again, it's private actors bringing it. Mylan I don't know if I haven't followed it for the last few months, but I know they were involved in an antitrust case over the product, the insulin glargine Lantus, and basically all the tactics that Sanofi used, including Orange Book patent listings and other things, to delay competition. And we did a report back in 2022-3 where we looked at how much Sanofi was able to earn because of the delay of 5 years, because of all the patent games they played. They earned an extra $14 billion. That meant less insulin for a lot of people. So this is happening in court. Whether that will be a decision that lands in favor of those of us who are interested in strong competition, we'll see. So I don't know where that is.
And when you go to Congress, when you're lobbying Congress, you're talking to Congress, you're talking to key decision makers. Did the eye-popping amounts of money, does that get people's attention? Do you think that changes some people's interest in doing this? Because even when we first started talking about this, the numbers were not even really quite close to what we're talking about now. I mean, it might have been 10 years ago or whatever, but these are just such eye-popping, astronomical numbers. Does that get more attention? Does that pique the interest of lawmakers more now?
Um, I think the Humira example has still sort of vibrates through people. I think that was the first one which really struck people, and that's what led from 2019 onwards, at least in terms of the periods that we've really focused on this issue here in the US. That's what has led to some of the actions now with these bills. We're 5 years later, we're seeing them still hanging around in Congress, trying to go through. Um, but I think in terms of the recent report with the Ozempic and what have you, we're still waiting to. These things take about 6 months to filter through. So we're still kind of speaking with people, and obviously with the election cycle, a lot of things nothing was really happening, and so now we're in the Trump's administration. We're waiting to see where they want to act and what they want to do, and I kind of predicted that they would focus on the PBMs and not the drug companies, and that's largely been the case. I think even though the most favored nation ruling is something that seems to have had a lot of attention, I think there's a number of reasons why I don't think that will lead to anything. But yeah, I think I don't think there's enough vigor in terms of taking on these issues with, like, when you look at $166 billion, I think that's outrageous. It just seems to be there's so much going on in the political space at the moment that doesn't seem to be bothering people.
And when you talk, are there any generic companies that are willing to just be more aggressive and litigious and just like hire a bunch of lawyers and deal with all this stuff that you think is worth paying attention to, sort of pioneers on the generic side? I mean, that would be one interesting way to look at this. It's like, okay, but from my experience, there's so many generics that used to just do generics that now also do branded. It's like, it's very confusing. I'm like, wait, are they the generic? Are they the brand? Wait, who's suing who? I mean, you know, what what's your take on the state of the generic industry and their willingness to fight these fights, and also the capacity to really have 5 or 6 for each drug? I mean, there's been so much consolidation. There's been so much sort of hollowing out of the generic industry. I'm curious to get your assessment of where that is.
Yeah, I think the consolidation that's happened in the generic space it's kind of hurt the ability to have more robust competition. I if there is a potential light, there's companies like Sandoz which have spun out of Novartis, which was always a generic arm of Novartis, but now has spun out independently. They seem to have, at least from the conversations I've had with them, they recognize the patent problem, and I think to its credit, the AAM, which is the generic sort of lobby group in the US, they've always been identifying some of the issues with the patent sort of system and some of the games that get played, the continuous litigation and so forth. I think there's this kind of launching aggressively is what used to happen in the 70s, where a company would just launch and then see where the litigation ended. That's kind of diet. That doesn't really exist anymore. I think because of the way the law has shifted, it's not in their favor. Some companies might still try and do it, but it's very few and far between. So no, I think companies, generics, they're always looking for opportunities to get into the market. I mean, I've had conversations with companies that have been trying to get in. For example, they've spent millions litigating. I mean, I don't want to name names because I can't, but one example I can remember, that's a company, biosimilar, spent 40 million just litigating, trying to get into the market, and it's insane. And so everything's a barrier for them, and I think the biosimilar market is going to shrink if we do not change something soon. We're going to have less and less biosimilars in the US, at least. But I think there are some potential stars out there who are finding ways. I mean, one great example is, and it's not in the US, unfortunately, is Canada. Apparently on Ozempic, the underlying patent, semaglutide, Sandoz recognized that Novo Nordisk forgot to renew the patent, so they might be able to get in a year or two earlier, which is, could save billions in Canada. But we don't unfortunately have any good news like that here in the US.
Is there, are the rules internationally as problematic as here? Or are there any jurisdictions internationally, and then, we're over time, I gotta let you go, but anything internationally to look at where other countries are doing something interesting, and not being so sort of captive to pharma on just on figuring out this pricing and patent problem?
I mean, we just have to look at, I'm not saying Europe's perfect, don't get me wrong, but we just have to look at the fact that generics or biosimilars enter into Europe on average, like by our count, looking at these drugs that we've looked at, anywhere between 4 to 6 years earlier. That says a lot already. And I'm not saying that there are patent standard issues in Europe as well. They've got some of those same problems, but at least they don't have some of the processes that the US has, which allows these tickets to be built around patents that cause heavier delays in litigation and so forth. So even just from that procedural aspect, I think there's things that could be improved, which are not happening at the moment. There have been some attempts. I mean, the bill by Welsh and Hawley is attempting to fix some of that, but it doesn't go far enough. There could be a lot of different things that we could be doing, even from a procedural thing. Never mind like assessing what should get a patent or not, just from a procedural thing that helps these companies build up all these patents. We could eliminate some of those routes.
Well, as always, super fascinating conversation. Overpatented, overpriced, available on I-MAK site. Please read it. Very, very interesting. Tahir, thank you so much for doing this. Such an incredible conversation. So much to ponder and dig into.
Yeah, I appreciate it, Teddy. Thanks for having me on again.